Hey guys, welcome to our video. In this video, we'll answer this question that we received. My car was repossessed and today I got served with a lawsuit for $24,000 related to that car. I cannot afford a lawyer and I cannot file bankruptcy. What can I do? So I suggest to you that there are 5 steps. Number 1, figure out who's suing you. Is it the original creditor or is it a debt collector, a debt buyer? Generally, and this video is based on Alabama law, and it may be similar in other states, but this is where I practice is Alabama. So generally, it is much easier to be successful against a debt collector or a debt buyer rather than the original creditor. So when you have somebody that says, well, we bought the debt, particularly if they say, we bought the debt from a company who bought the debt from a company who bought the debt from the original company, well, there's a whole lot of layers in there. So you need to figure out, all right, the one that's suing me, is that who I've been making my payments to and who repossessed the car, or is this somebody that's come along and bought the so-called deficiency? So deficiency is the amount you owe minus what was recovered at the repo sale. And that number is your deficiency. So is this the original creditor or is this somebody that bought it? Because that makes a big difference. Number 2, make sure you understand your time limits on responding to the lawsuit. So if you're served in small claims court in Alabama, you have 14 days to respond. If you're served in district court in Alabama, you have 14 days. If it's circuit court in Alabama, you have 30 days. Make sure you understand when were you served. Now, this person said they were served today, so that makes it easy. But if you realize, I was served a week ago, well, then you burn through a week of your time. So you want to make sure that you respond before the deadline, because after the deadline, you can still respond, but every day there's a danger that the person that sued you, the company that sued you, will file for a default judgment, and those are almost granted immediately. And so now you have a judgment against you. So remember, first step is this a debt collector or the original creditor? Step number 2, make sure you understand the time limit. Number 3, gather up your documents. So get your original contract. Now, it's probably attached to the lawsuit, but take what they attached and compare it with your own records if you have it. Make sure that the contracts match. Sometimes they don't. And the very fancy term for this is somebody's got some splaining to do when that happens. So see if they match. Look at your letters that you would have received leading up to the repo. And those letters will say, hey, we're going to repossess your car. And then what happened after they repoed your car? You should get a letter that says, hey, we've repossessed your car. We're going to sell it at a private sale, at a public auction, and they'll give you the date. And then after they sell it, you should get a letter that says, okay, we sold your car on such and such date. You owed $40,000 on it. We got $16,000 at the auction. So therefore, the amount you owe us is $24,000. If you did not receive those letters, that can provide you some defenses when somebody's coming after you for a deficiency. Now, step number 4 is check your credit reports. See if there's anything on there that conflicts with the lawsuit. So let's say it's the original creditor suing you, and they're suing you for $24,000. And on your credit report, it says you owe $10,000. Wait a minute. Now, why would it be different? And that's something that you could bring up in court, bring up at trial, bring up in discovery, and say, wait a minute, there's some contradictory information here. Or maybe it says that you don't owe anything. Now, you have to be careful it doesn't say charge off, because that can kind of distort things. But the point is, you want to check your credit reports, see what's being said. It might be that a debt buyer claims to have bought your debt. They're suing you for $24,000, but the original creditor is still on there saying you owe $12,000. Well, now how's the debt buyer going to say you owe $24,000 if the place that they supposedly bought it from is telling the world that you only owe $12,000? So again, it's worth pulling your credit reports to check on this. Then number 5, talk to a consumer protection lawyer to figure out your options. When people come to us, we have a very simple approach. We go through 5 options. Number 1, file bankruptcy. Now, very rarely do we recommend that, but it's something you should consider. Now, this person says that they can't file bankruptcy. Maybe they've already filed it. Maybe they have a security clearance that they would lose their job if they filed bankruptcy. So, it's something to consider. Number 2, can you fight this lawsuit on your own? Now, this being $24,000 would be in circuit court, which you still can represent yourself, but it's very difficult in circuit court, much easier in small claims court. And so that may not be a good option, but look, if you have no other options, you go with that. Number 3, can you settle this on your own? A lump sum settlement, a monthly payment settlement. Can you do this on your own? Obviously, you save money, you don't pay an attorney. The downside is you're also on your own. You don't have an attorney. Then option number 4 is hire a lawyer to fight the lawsuit. Now you have to factor in there's a cost to hiring that lawyer. What are your odds of success? What happens if you lose the case? Because you paid the lawyer money and now you lose a case. What happens? Are you prepared to deal with that? What does a lawyer say about that? And then option number 5 is hire a lawyer to settle the case. And that could be paying a lump sum, doing a monthly settlement. Again, you have to factor in the cost of the lawyer. Now, I'll tell you this, if we're dealing with an active lawsuit by a debt collector, we have a very simple policy. We don't pay them anything. So our settlement is you pay them nothing. And so, we have some ways that we encourage them to settle even though we're not paying them anything. But the point is you have to understand if you go that route of hiring a lawyer to settle it, what's the cost going to be? What are your chances of success? What happens if it doesn't settle? Will the lawyer then represent you in terms of fighting the lawsuit? If you hire a lawyer to settle, will they actually appear in your case, or are they just kind of behind the scenes? So definitely things to look at. We have a ton of videos on those 5 options. But the point being, you've got to find out what your options are. And this person says they can't file bankruptcy. Maybe they really can. They say they cannot afford a lawyer. Maybe they can. And one way to look at whether we can afford to do something is, well, what's the downside if I don't? What's the cost? So if this person loses this lawsuit, they have a $24,000 judgment against them that'll likely be on their credit report, the judgment, and they can be garnished about 25% of their take-home pay. Any money in a bank account, unless it's protected funds like Social Security, can be wiped out. There can be a lien on their house. Their house can be sold at a sheriff's sale. It's kind of like a foreclosure in a way. So we have to balance how bad is this versus what's the cost to settle it, what's the cost to hire a lawyer, or even the cost to look at bankruptcy. So anyway, hope that that's helpful. If you're in a situation like this, I would suggest going through those 5 steps is a useful approach. Who's suing you? Debt collector, original creditor. What's your time limit to respond? Look at your documents, look at your credit reports, and then finally sit down with the consumer protection lawyer and say, what are my options here? And what's the good and the bad of each option? So appreciate you watching this video, and I'll see you in the next one. Thanks. Bye.